everyone, I'm Nazarat Fatima and you're watching LiveLaw. The Supreme Court has stayed the order to ban the sale of gutka, pan masala, flavored or scented food products or chewable food products that contain tobacco or nicotine. In 2013, the state government had imposed a ban on tobacco and gutka products using a temporary provision under the Food Safety and Standards Act 2006, and it was extended every year through various notifications. In January, the Madras High Court set aside the notification based on the finding that the Commissioner did not have the power to issue such notification in the first place. The High Court noted that such a notification can only be issued temporarily, and issuing successive notifications would confer power that is not covered by Food Safety and Standards Act or even the Cigarettes and Other Tobacco Products Act. Senior advocate Kapil Sibal, who was appearing on behalf of the state of Tamil Nadu, made a point that the Food Safety and Standards Act confers power on the state government to prohibit manufacture, storage, distribution or sale of any food article in the whole state in the interest of public health. He said, and I quote, "We are protecting people from disastrous consequences of having food articles that result in cancer. It is the government's duty to protect people from the dangers." He said that the ban is based on the mandate fixed by the court in Ankur Gutka versus Union Asthma Care Society and others, and pointed out that the only issue that needs to be considered by the bench was whether the power to issue the notification can be exercised year on year. It reminded the bench of the fact that the ground for challenging the notification was that the Food Safety and Standards Act does not allow banning by successive notifications, each operative for a year in a routine manner. Mr. Sibal also emphasized over the fact that in the case of Ankur Gutka, the manufacturers were selling pan masala without tobacco with flavored chewing tobacco in separate sachets so that the customers could buy the pan masala and flavored chewing tobacco and consume them after mixing. He said that the respondents contend that the power to impose ban lies with the central government, and does that mean in case the central government does not take action, the state governments will be left powerless? Meanwhile, senior advocate M. Singhvi, appearing for one of the respondents, argued that the law does not permit what the Tamil Nadu state government is doing. He made a few contentions, speaking of which he submitted that there is no allegation or statement of fact that the respondents have indulged in mixing the products and selling them together. And just because the state government is not able to prevent the shops from doing so, it cannot be the basis for imposing the ban. While making his contentions, he also mentioned the powers of the Food Commissioner, which include the power to prohibit in the interest of public health the manufacture, storage, distribution or sale of any article of food, either in the whole of the state or any area or part for such period not exceeding 1 year. Moreover, speaking of whether tobacco is food or not, he said, "Chewing tobacco is never ingested. It is spit out. Tobacco is not food." He said that primarily the state government does not have the power to impose a ban, and moreover the ban cannot exceed 1 year. But in the present case, the state has banned or rebanned for 9 years. He also said that Cigarettes and Other Tobacco Products Act is a central legislation and the state cannot exercise the power beyond its jurisdiction, saying that it revolves around public health. Towards the end, the bench asked Mr. Sibal if tobacco products can be considered as food products, to which he responded in a very affirmative manner and said that the Supreme Court says so. He also requested the bench to ask the respondents to file an affidavit stating the end use of the tobacco manufactured by them. He said, and I quote, "They should disclose the end use of the tobacco they manufacture." The bench, comprising Justice K.M. Joseph and Justice B.V. Nagaratna, granted stay in the order and clarified that in the event the manufacturers have a case that their activities are not covered by the notification issued by the state, they may approach the appropriate forum seeking redressal. What are your views on the ban? Do you think that the state government is justified in imposing such ban? Do let us know in the comment section what you feel about it. For more details about the case, go to our website and check out the story. Thank you for watching. If you like our videos, please like and share. Also subscribe to LiveLaw and don't forget to press the bell icon for notifications.